Hello everyone, and thank you for tuning into this webinar. My name is James Nelson. I'm a solicitor in Sharpe Pritchard's real estate team, and I'm co-hosting this presentation with my colleague Lily Reid-Hunt, an associate also in our real estate team. The title of our presentation today is Telecommunications, a Human Right, which is a reference to a fairly recent court case whereby a barrister acting for a telecoms company claimed that the right to mobile telephony was a human right. Now, the assertion was perhaps slightly whimsical, but it was an attempt nonetheless to emphasise the importance of telecommunications to both businesses and individuals in the modern age. As such, the aim of our webinar is to provide landowners with an insight into recent changes to telecommunications law in the context of land and property, and then to set out the associated risks to landowners arising from such changes.
Thanks, James. So during this webinar, we will be covering the following topics. Firstly, current affairs and the relevance of telecommunications in today's society. Second, telecommunications and land pre-2017, so the legal and regulatory landscape before the introduction of the new Electronic Communications Code. Next, an overview of the 2017 Electronic Communications Code, or the new code. Then, Tales from the Tribunal, which is a summary of a couple of recent decisions clarifying the application of the new code. And finally, takeaways and considerations for landowners. So we will be covering some practical tips for landowners dealing with telecommunications operators.
Okay, so current affairs. What's new in the world of telecommunications in the UK? Well, firstly, we've got the recent rollout of 5G, the successor to existing 4G networks. 5G is up to 4 times faster than average Wi-Fi connections, and there's been a real government drive to facilitate the rollout of telecoms masts to be put up across sites all over the country. Which leads us to the recent Huawei episode. Huawei had provided equipment to facilitate the new 5G networks across the UK. However, owing to perceived security issues, the government have announced that all Huawei equipment must be stripped from the UK's 5G network by 2027. This in turn is a fair setback for the UK government rollout and will ultimately delay the rollout of infrastructure for 5G. And then finally, we've got Speed Up Britain, which is a new campaign fronted by Ed Vaizey MP to close perceived loopholes in the legislation that we're about to discuss. It's been set up really to engage with industry and government alike to, I suppose, streamline the process for which telecoms companies can roll out new projects. So telecoms before 2017, the first real effort to legislate to accommodate telecoms equipment on land and property was in 1984, the first Electronic Communications Code, or old code. And this was done against the backdrop of 1980s privatisation, namely of British Telecom. As you can see, we've got a picture of Maureen Lipman in the famous 1988 BT advert. And the old code was originally designed to facilitate landline telephony, and it regulated the relationship between operators, for example, British Telecom, and public and private landowners, similar to that of a landlord and tenant relationship. So what core concepts did the old code set out? Well, firstly, there was a right for operators to install equipment on land. And secondly, consideration or rent payable to the landowner was done on a commercial basis, really for the parties themselves to determine. And then next, the operators acquired particular statutory protections, such as protections from being removed from the site. However, as years went by, the code became quickly outdated and was described by one judge as one of the least coherent and thought out pieces of legislation on the statute books. And as you'll recall, around the year 2000, there was a rapid advancement in digital technology, such as the advent of the iPhone, as you can see here, which was released in 2007, and then the explosion of social media, the likes of Facebook, LinkedIn, Twitter, Instagram, etc. So the government realised that the law needed to be brought up to date, and this culminated in a Law Commission review of the existing old code. And the key the key recommendation was outlined very clearly, which was the ability for operators to apply to have rights imposed on landowners where it would be appropriate to do so and agreement could not be reached. And the report in turn paved the way for the new legislation. So the law changed on the 28th of December 2017, and the new code was brought in under the Digital Economy Act. So what was the overarching purpose of the new code? Well, really, it was to modify an ineffective law from the 1980s to be fit for the modern market and to enable the rapid rollout of digital infrastructure across the UK. Effectively, you could say telecoms was almost to be on a par with other essential utilities, hence the human right. So what were the main changes brought in by the new code? Well, firstly, the new code has been drafted to weigh in heavily with the requests of operators. It's designed to release operators from the perceived financial and legislative shackles of the old code. And it's forbidden under law to contract out of the provisions of the new code. Secondly, there's been a massive shift in terms of the calculation for valuation. Previously, landowners could elicit a fairly good yearly rent for allowing or enabling operators to house their equipment on the land of a landowner. However, the new law means that the costing is calculated by the value to the landowner, not the operator, meaning that the rent payment is considerably reduced. And thirdly, there is an ability for landowners to terminate code agreements, and it's been made far trickier. So the operator can now apply to court to effectively argue that it should be allowed to remain, even if the landowner wants to still get rid of them. And then finally, the new law grants automatic code rights to operators. For example, the right to share equipment with other operators. For example, a consultation was released in July to amend existing planning laws. And in doing so, this would remove planning hurdles and effectively allow masts to be built taller and in some instances without any prior approval. There is also a rumour that the European Communications Code, an existing piece of EU legislation, may also be brought into UK legislation as well. I'll now hand over to Lily, who will take you through some recent court cases.
So now we'll take a look at the main points coming from decisions issued by the Upper Tribunal, which is the forum for hearing disputes under the code. And the tribunal has the power to impose code rights on landowners and occupiers. Now I'm going to briefly summarise a couple of recent decisions and then focus mostly on the next section, which is practical considerations. So I'm hoping that you've read up on the basic principles and tests under the code in the article that James and I have published on our website entitled Code Red Guidance for Landowners. These Upper Tribunal decisions are important because they clarify how the code works in practice. So the first is CETL and the University of London. The tribunal here held that the code covers the grant of interim rights, so those of initial access for surveys, which aren't expressly mentioned in the code, as well as final code rights that are expressly mentioned, so those of installation, operation, etc. of telecoms equipment. The test for the grant of code rights is in paragraph 21 of the code, and it has two limbs, as you can see on the slides. The first, the prejudice to the landowner can be adequately compensated. Note that this doesn't mean that compensation will actually be paid. And second, the benefit will outweigh the prejudice, having regard to public interest and access to a choice of high quality networks. The test under the old code simply referred to public interest in reasonable access to networks generally. 9 out of 10 times the test in the new code will be met, and it was in this case. Another option for landowners looking to resist operators in the development is the development exception, which was relied upon by the landowners in the Chichester decision. The tribunal held that the same assumptions as ground F of the Landlord and Tenant Act apply under the code to landowners resisting the grant of code rights based on redevelopment plans. For those of you who are not property experts, ground F is a way for landlords to terminate a secure tenancy, and this test requires a genuine intention to develop, and the proposed development must be practically possible. In this case, the landowner refused EE rights because they had plans to develop their own network on the land, and the landowners had planning permission to do so. The tribunal held that the Ground F test was not met because their proposal was purely intended to keep EE off the land, it was uneconomic, plus it probably wouldn't provide good broadband. The next case, which is especially relevant for local authorities, is EE and Hutchison 3G and the London Borough of Islington. Here, EE wanted the council to grant code rights so that they could install and operate a telecoms mast on the roof of a block of flats owned by the council. The main takeaways from this case were EE had time pressures because they were seeking to rehouse a mast from a building that was being demolished, and the tribunal factored this into ordering interim code rights for EE to survey the council's building. The tribunal also reprimanded the council against vexatious or time-wasting conduct that could be avoided by a basic level of cooperation. The second is the valuation methodology adopted by the tribunal for rent under a final code agreement. We don't have time to go through the parties' respective methodologies in full, but the tribunal said that historic rental values were irrelevant because they did not apply the no network assumption that the new code prescribes. So the rights to be assumed are those actually granted, but the purpose of them must be disregarded. Second, a willing seller and willing buyer argument is not of itself satisfactory. The value of the land must be considered in terms of its unique characteristics and not the number of potential bidders. Finally, the tribunal looked at the service charge paid by residents of the building, which included repair and maintenance of the rooftop by the council, and they included this in the rental figure under the code agreement. Basically, EE had arrived at a rental figure of £1 using methodology that focused on potential bidders and compared the site to a roof garden or solar panels, uses that don't attract rent, whereas the council had arrived at a figure of around £13,000 based on previous leases that had granted to operators and compared the site to storage spaces or car parking. It seems that the service charge paid by residents of £1,300 was the key here because the tribunal calculated the value of the site as £50 per annum, but ordered the rent payable by the operator as £1,000. So now a few practical considerations. The code is tilted heavily in favour of operators, and they've tended to opt for an almost bullish approach to get access and obtain code rights. The tribunal had referred to the 2017 Ofcom Code of Practice that should be followed when negotiating code agreements. This seeks to encourage cooperation between the parties and stresses that an application to the tribunal is a last resort. An operator acting outside the spirit of the Ofcom Code could result in the tribunal ordering costs against the operator. Where an operator is taking a bullish approach, it's worth responding to their letters reminding them of the Ofcom Code. We know from the Chichester decision that the redevelopment ground can be difficult to establish, and it is worth exploring other options. So our Telecoms Advisory Service has recently helped a client resist approaches from an operator on planning grounds. While the character or special location of the building is not enough to rebut the paragraph 21 test under the code, these may be factors in opposing the operator's plans as a permitted development. Some provisions of the code you can't contract out of, some you can. So you want to make sure that you're getting professional advice and the best deal. So if redevelopment is a potential ground for termination, but if the operator presents you with an agreement containing lift and shift provisions, then you're contractually barring yourself from that termination right. The final consideration that I will leave you with is that operators will often approach you with a draft agreement in their standard form. You need to be clear about whether this is an entirely new site or whether there is existing apparatus or an existing telecoms agreement in place. This might be in the form of a way leave or a lease. The new code contains transitional provisions that deal with agreements completed before December 2017, so before the new code was introduced. Basically, operators will try to get a new code agreement because the new code is so favourable towards them, but a different statutory process and notice requirements apply where there's an existing agreement. So check that the right process is being followed first and foremost. Also, you don't want to rush into a new agreement. Your existing agreement could have terms more favourable to you that you can rely on, especially in relation to assignment or upgrade. So the new code tends to put the public interest and acceleration into the digital era ahead of indefeasible rights enjoyed by landowners, which is why some commentators have likened telecommunications to a new human right. But with good advice and a plan of action, there are still ways that you can protect your property interests as a landowner. So please do get in touch with a member of our telecoms advisory team if you do require advice. And thank you very much for tuning into this webinar.